Hello, my name is Mike Meyer. I will explain to you today how e-visas work. And we will be talking about the E1, the Treaty Trader Visa, and the E2, the Treaty Investor Visa. First of all, e-visas are based on treaties between a foreign country and the United States. Usually they're FCN treaties, which are treaties of friendship, commerce, and navigation. The United States has many such treaties in place, for example, with Germany, with France, and even with Pakistan. However, you need to watch it because the United States does not necessarily have a treaty in place that covers both the E1 or the E2. You may have to choose or may have to choose a different visa category altogether. Let us start with the E2 visa, which in my experience is more common for Western European countries. The requirements for the E2 Treaty Investor Visa are that someone, a company or an individual, makes a substantial investment in the United States. It usually means that a company or an individual establishes a company in the United States and invests the capital necessary to get this company running. The term substantial investment is not clearly defined in the law. Here's an approximate guideline. Of course, the amount of investment must be sufficient to establish the business. Let's take an example. Let's say you are going to establish a translation company. Of course, you don't have to buy a large warehouse or buy trucks. However, you may have to buy certain software, you may have to rent an office, and you may have to hire staff, buy a computer, set up an internet website, and have a promotional brochure. At a minimum, in order to start a translation company in the United States, you should invest $20,000. Is $20,000 a substantial investment? It is difficult to say. In my opinion, $20,000 as an investment for an E2 visa is not sufficient. Usually, the total investment should be at least $100,000 based on my experience. That doesn't mean that you have to invest $100,000 up front. The officers understand that when you invest a company, you do it gradually. You establish a company, you find office space, you find equipment, you hire an attorney to help you, you hire staff. It is a gradual process. But in my experience, the officers would like to see a total investment of $100,000. Any amount that has not been invested by the time you apply for the E2 visa should at least be credibly explained in your business plan. And I'll come back to the business plan in just a minute. Another requirement is that the proposed investment or the proposed company in the United States produces more than marginal income. Let's say you're planning to establish a translation business. You invest, let's say, $100,000 in order to set up the business and get it going. And you expect that you will earn about $10,000 per year with that business. Well, in the eyes of the officers who review that application, that does not meet the more than marginal requirement. More than marginal probably means an income of at least $50,000 based on my experience. I mentioned a business plan earlier. Once again, if you establish a company from scratch, it is a gradual process. It takes time. So you should have a good business plan explaining what you will do, what you have invested so far, and how much more you will invest in the future. That business plan should explain how much revenue you anticipate, what the market looks like in the United States, and how many U.S. citizens you are planning to employ. A business plan is essential for a new investment in the United States. And you shouldn't just hire a consultant to write the business plan. You yourself should do your homework, review the market, and make sure what you're proposing to do in the United States makes sense. At the very least, if you hire a consultant to write you the business plan, you should be actively involved and you should at least write the first draft of your business plan. And of course, before to submit it to the Immigration Service, USCIS, or the U.S. Consulate, you should review it, make sure that it is accurate, and that you agree with all statements in there. Here are a few examples from my experience for successful E2 applications. In the past, I was able to obtain an E2 for someone who purchased a small optometrist business in a small village in upstate New York. Even though the total investment was only about $30,000 for the business, the lady proposed to spend another $25,000 approximately in order to upgrade all the premises and the equipment. And that, in the opinion of the consulate, was sufficient to issue the E2 visa. Of course, that application had the advantage that the lady was purchasing an already existing and already functioning business, as small as it may be. Usually, the officers do not like when the investor purchases real estate in the United States and counts it as part of the investment. However, I had at least one successful E2 case where a gentleman purchased a small hotel in Florida. The cost of the hotel was approximately $600,000, and of course, a large part of it was because of the value of the real estate involved, which was the land and the hotel building. In that case, the U.S. consulate did approve the E2 visa because it was essential for conducting the business of a hotel. The E2 can be issued not just for the investor, if it is an individual, it can also be issued for specialists that are needed for the business. For example, we successfully applied for an E2 visa for a large German-style restaurant in Nevada, and this German-style restaurant needed specialty cooks that can prepare Bavarian cuisine, Bavarian cooking. The U.S. consulate has also approved those E2 visas for specialists, in this case Bavarian specialty cooks that are needed to successfully operate this restaurant in Nevada. Other examples of E2 specialists may be, for example, engineers. Let's say, for example, a company establishes a manufacturing facility in Alabama and needs specialized engineers that have to be brought over from Europe. Those would certainly qualify in the specialist category and will most likely obtain E2 visas. What about the spouse of someone who has an E2 visa? The spouse, the husband or wife, and the children of someone who has an E2 visa also receive E2 visas. However, they are not authorized to work based on those E2 visas. For them to be authorized to work in the United States, they have to apply for a separate work permit, a so-called EAD or I-765, which is the form that has to be used in order to apply for a work permit. Please note that the children on E2 visas are not authorized to work. They cannot work. It is only the spouse that can obtain a work permit. The other E-visa, the so-called E1 visa, is for companies that do substantial business with the home country. Let's take the example of Germany. Let's say you have a company that purchases certain products, let's say Native American products in the United States, and exports at least half of them to Germany. Such a company would certainly qualify for the E1 visa. Even though the E1 visa does not require a specific investment, officers generally require that there is proof of sufficient assets to support such a company in the United States. That is, the E1 visa category only requires that at least half of the trade or business activity is with the home country. Nevertheless, the officers who review E1 applications generally expect there to be sufficient assets to support such a company in the United States. In order to apply for an E1 or E2 visa, there are two ways of doing it. One would be through the Immigration Service, the USCIS, if the beneficiary of the petition is present in the United States. Then the application would be filed with USCIS with the service center. If the beneficiary is outside the United States, then the application will be processed through the U.S. consulate. In some countries, there are only specific consulates that process e-visa petitions. For example, in Germany, it is Frankfurt. In the United Kingdom, it is London. There's one fundamental difference when one applies for an e-visa in the United States through USCIS or at the U.S. consulate. Because of the different regulations that the different agencies have, USCIS versus the U.S. consulate, which is part of the Department of State, USCIS will issue the E2 approval for only 2 years. And of course, if the person travels outside the United States, he or she would have to go to a U.S. consulate where the process would start anew for the E2 visa. Now, if the e-visa application is processed through a U.S. consulate, the visa would usually be issued for 5 years. The e-visa is a non-immigrant visa. That means it cannot be easily converted into a green card. However, there are ways and means of doing it. For example, one way would be a labor certification. But the basic assumption is that the person who has an e-visa or who is applying for an e-visa does not have the intent to immigrate to the United States, which is non-immigrant intent. Even though the e-visa is a non-immigrant visa, it can be extended indefinitely. I have seen people who have been on e-visas for almost 20 years. There's one problem that often arises with e-visas. As I mentioned before, the e-visa may be issued by the U.S. consulate, which means that USCIS, the immigration service in the United States, has no record of this visa being issued. So if someone applies for a Social Security number, the Social Security office will forward the information to the immigration service for verification that this person is authorized to work. As USCIS has no record of approving a work visa for this person, this will often lead to confusion. Furthermore, since dependents receive the same type of E2 visa, which I used in my example, the officer who reviews it cannot tell whether this is the application of someone who is just a dependent and would need a separate work authorization, or in the case of children can't even obtain work authorization, or whether it is the employee himself or herself. Therefore, for these two reasons, which were first, there's confusion because the E2 dependents receive the same kind of visa, and because USCIS has no record of approving a work petition, there can be delays and additional questions when it comes to obtaining the Social Security number. Let's assume you do get an answer from the Social Security office and it tells you that they could not verify that you're authorized to work in the United States. You should be prepared to obtain a copy of the entire petition that was filed and shows that you are in fact authorized to work, as you are the direct beneficiary of the petition. Usually this problem can be resolved if you just provide a copy of that petition to the Social Security office where you applied for the Social Security number. If you have more specific questions about e-visas, please consult an immigration attorney. Thank you.